Good evening. It's Tuesday night, 8 o'clock, and this is the Bob Leonard Show. We'll be with you for about an hour, and we take the stories that you've been reading about in your newspaper and watching on television the last week or so, and we go behind the stories. We put our spin on it, and we tell you what's really going on with these stories. And as I say, we'll be with you for about an hour. And if you miss it here on Tuesday night, we used to be on it, repeated on Friday night from 8:30 to 9:30, but that time has been taken by other people now. So we're on flinttalk.com. And it runs, I understand, 24 hours a day. So if you miss this, you can go to your internet and it'll come up by punching in flinttalk.com. Like we tell you every week, what we say here in regard to some of these stories is really our opinion, our interpretation. And you can accept or reject it, but we're obviously going to have our say. So last week we missed some of the things we wanted to talk about, but we want to talk to you tonight about the latest act in the tragedy of the Flint Board of Education hiring of a pedophile to help run the Flint School Board. And we'll also talk to you about what we believe is a sellout of the City of Burton citizens by a majority of the Burton City Council by filling 2 council vacancies with political allies of the controversial Mayor Charles Smiley. He had Ralph LeDuc and just appointed, and about a month ago he had Jeff Majors appointed. And I say he because these are people that were Smiley's public works directors for a number of years out there. And we'll talk about that and why we think those were bad choices. We'll also look at whether any progress has been made to get the one sitting Flint council person and 3 former councilmen of the city of Flint to pay back to the Flint taxpayers for their illegally obtained retroactive pay they gave themselves. This happened about 1.5 years ago. We'll talk about that also. Also, we want to update you on the status of the Peeping Tom police officer from Argentine Township. I think you'll be interested to hear what we found out on that case. But first, as I started out, let's clean up a few matters we didn't get to last week. Here's something that I'm sure is going to aggravate a lot of people. If not a lot, most. Comcast has notified various local governmental bodies in Genesee County, including the city of Flint, that they intend to raise rates by 5, 6, 7, 8, 9% in the near future. You know, remember, just recently our state representatives and state senators were talking and telling us that if we give up local control of our cable company and turn it over to the state, we would increase the competition and lower prices would result. They all voted for this new law, and the first thing out the door is an increase in the rates that I've mentioned to you. I mean, you can't trust any of these politicians to tell you the truth. Now here's another part of this big picture. We're told Comcast is shorting Flint on its collection of the franchise fee by about $175,000 to $200,000. Now this is the fee Comcast customers pay on their monthly bill, and it's listed there, that is supposed to be passed through to each community Comcast has a contract with, like Flint, Burton, Grand Blanc, Flushing, and so on. Now this money is used for governmental services. It's like a tax. It's a tax you're paying as a franchise fee that you don't have to pay directly. I think it's a little deceitful because, you know, if the council and the mayor came back to the public and said, I want a 5% tax increase, they'd be turned down in a minute. So what they do is they go in the back door and have this franchise fee. But whatever, even if it is a little deceitful, Comcast still owes the city of Flint a lot of money. And apparently the city may have to sue them to get it. Now here's another matter you'll hear first on this program. And you know, it has to do with acting police chief Gary Hagler. We're told he is interested in a vacant police chief job in Flushing. He's even made an application. You might recall this job became open when Faye Peak, the Flushing police chief, left the Flushing job to take a police chief job in Kalamazoo. You see, such a move by Hagler, if it should happen, would have enormous implications in the city of Flint, where there is presently an open, warlike atmosphere existing between Hagler and the rank-and-file police officers, to the point that it is interfering with the quality of law enforcement that the citizens of Flint are receiving. If this change comes about, frankly, I believe it probably would be in the best interest of both Flint and Flushing. I think Flushing would get a good police officer, and Flint would eliminate that unnecessary, unfortunate confrontation between the Hagler and the police officers, the unions, the black officers, the regular union people, the rank and file guys and gals. Now here's an update on the Genesee County probate court lawyer that's accused of embezzling hundreds of thousands of dollars from dozens of clients, incapacitated by age or some other disability, whose finances she was directed by the court to manage. Now, she now claims the lawyer in an embezzlement case says she was blackmailed with sex tape. And she's claiming that she was stealing from her clients money to pay a blackmailer who was threatening to make public the sex tape, apparently that she plays a prominent role in. That's the implications of what she's saying. Now, Genesee County Prosecutor David Layton said he believes such a story is really far-fetched. And it really doesn't make any difference. If she stole the money, she stole it. Whatever reason she stole it for, she had no right to it. So I don't know whether she's just trying to get some sympathy with such a story, but that's what it says here in the Detroit Free Press here about a week ago. Now, here's an interesting case, and I just want to talk a minute on it. And you've seen this in the paper. Failed shooting self-defense. It says an Atlas Township homeowner who shot and killed his girlfriend's ex-husband as the man invading his home Saturday night acted in self-defense, Genesee County Robert Pickell said Thursday. Now, keep in mind, Pickell doesn't make that decision. The prosecutor makes that decision. But I think Pickell is right. It's so obvious. And this guy went wild, Pickell said, about Tofyan Novaka, 51 of Sterling Heights, who was shot after he fired at least 2 bullets into the man's house, broke in and stalked up the stairs towards the man and Novaka's ex-wife. Our investigation shows the homeowner was defending himself. Well, that's pretty clear. I mean, this guy took shots in the house, outside the house. And this fellow called 911, and the shooting was going on while he called 911, and before the police arrived, the guy broke into the house and was coming at him with a gun, and this guy just shot him. This is the classic case of excusable homicide, or as most people recognize the term, self-defense. I don't think there's any question that that's going to be the result from the reports that I just read to you from the newspaper. Now here's another troubling thing that I want to talk to you about, and it's bill would allow some cases to permit hearsay evidence in criminal cases. Here's what it says. A divided state Senate approved legislation that would change probable cause hearings in criminal cases, with Republicans advocating for the victims' rights, that's what the Republicans say, and Democrats saying defendants' rights would be trampled upon under the proposal. Now, not defendants who committed crime, but defendants who have been charged, who may not be guilty. Then it went on to say, defendants should have the right to question witnesses who might have an axe to grind, failing eyesight, or a faulty memory. Now, here's what this provision would do if it passed. If a person is charged with a crime, in a felony crime, they're entitled to a preliminary hearing. That's kind of a probable cause hearing. It's like a grand jury, only our process is not done in secret. Everything is done out in the open, and that's the value of a preliminary hearing. And the idea of a preliminary hearing is for two primary purposes. One, to determine if a crime has been committed. Is there a corpus delicti, the elements of a crime? Breaking, entering, you got to show those kinds of things. If you show that that's happened, somebody has a home that's been broken into, the person doesn't know who broke in, but the doors kicked in, they went into the house, they stole something. So you got that's the corpus delicti of the crime. Now you have to have the second step, which is the probable cause to believe that the defendant that you have charged committed the crime. Now, you don't have to prove at that point at the preliminary exam beyond a reasonable doubt. You're just doing these basic things that help you weed out people who aren't guilty. That's the whole idea of preliminary hearings. Now, this Republican effort to eliminate a hearsay rule in these cases would, in many cases, prevent this, because all this, let's suppose your next door neighbor who hates you and you've been feuding with him for years, calls a police officer friend of his and says, hey, the guy next door to me, Joe Smith, just stole my car. Now, under the present system, this guy, if he's not telling the truth, maybe moved the car to another section in town and said that's how it got there. He saw him stealing it, which isn't true, let's say. He just hates this guy. Under the present law, this man would have to go to court and testify under oath and be subject to cross-examination by the defendant's counsel. And any lawyer worth his salt will tell you cross-examination is the key in any criminal case, actually in any civil case, to be able to get to the basic facts. Now, under this proposed law by the Republican legislatures, and I'll explain to you why I'm emphasizing Republican, because I'll get to that in a moment. Under this proposed law, this person could just go to a cop friend of his and say, hey, Joe Smith next door I saw him steal my car. Cop goes in, gets a warrant for him, goes to court. Now, under this law, the complainant, who you would be normally cross-examining and may probably be able to show he's lying or exaggerating, whatever the case may be, and the case would be dismissed. You don't have that. He doesn't have to come to court. The cop can go in and tell the court and testify under oath what this guy told him. Now, he's telling the truth. He's under oath. He's subject to cross-examination. But what good do you cross-examine this guy for? He's just telling you what somebody told him. Now the tragedy here is people say, well, when they get to circuit court, this complainant would have to testify. And you would have a right to cross-examination. But see, that means you have to wait 1.5 years with this hanging over your head. That maybe you could have eliminated, probably could have eliminated the case at the preliminary examination if you could have cross-examined this liar. Now you wait 1.5 years. Now when the case comes up, you've paid attorney fees. People looking at you when you walk down the street saying, hey, you know, that guy did this, this, and this. And it may not be true, but they don't know it. They read about it in the paper. But if you have a preliminary examination, you can eliminate this problem in 10 to 15 days. And you can show the person was lying. Or he won't come into court and the case will be dismissed. 75–80% of all the criminal cases that are prosecuted are eliminated at the preliminary examination. Because the witnesses, like the complainant as it is today, as the law is today, the complainant breaks down under cross-examination. That is, you find all kinds of holes in their testimony, and the prosecutor is sitting there saying, that isn't what the police report said, case dismissed. But in the meantime, if the police can come in and say what somebody told them, it goes to circuit court. It won't be dismissed in the preliminary. You might get it dismissed in circuit court. Or, which happens often, a guy finds himself in the predicament of being charged with a felony where he may go to prison, so he'll plead guilty to a misdemeanor that he's not even guilty of, just so he won't be exposed to going to prison. And this is, if we had the hearsay rule eliminated, that's what could happen in many cases. And that's why it's not happening today to any degree of regularity. It happens on some occasions, but it would open the floodgates in something like this. Now I mentioned the Republican Party. Here's why I say that. There's presently a movement by the supporters of the Republican Party, the insurance lawyers, big businesses. They want to eliminate the jury trials. This is the foundation of our American justice system. And this would force everyone with a claim to go do what they call binding arbitration. They've set that up now in many of their contracts where people, you know, a 50-page contract or insurance, there's a binding arbitration clause in there where if they screw you, you can't sue them. You only could go to an arbitrator who they decide will be the arbitrator, and you're out in left field. You're not going to get anything. And an arbitrator is one person usually decides everything: the liability, the damages, the pain and suffering for the injuries. Arbitrators are much less sympathetic about a person's injury than the people who would make up a jury who live in your community. Now the Republican Party is spearheading this effort on behalf of a big business and the insurance companies, because those are usually their supporters. Now the elimination of the hearsay rule, and this is why what point I think you have to consider. The elimination of the hearsay rule is the first step towards this effort to eliminate all these protections that we had in the jury system, in the American justice system. Jury trials, the elimination of jury trials will not be far behind. They'll stick that arbitration and everything. You know, today there's a federalist system in the United States that attracts all very conservative lawyers, and it's called the federalist system. Most of the Supreme Court, new Supreme Court justices, and the Michigan Supreme Court justices that have been appointed by Engler during the 12 years he was governor, and the new justices supported by Bush in the last year or so, to the Supreme Court, to the Court of Appeals, to the District Court, are members of the Federalist system, the Federalist program, which is protect the insurance companies, protect big businesses. Individual rights are going out the window. And that's why it's so important that you know who your judges are and where they're going. Let's go now to the most recent event involving the criminal charges filed against Lucas Anthony, the friend and confidant of the Flint School Superintendent Walter Milton, for failing to register as a sex offender as required under Michigan law when he was hired, or when he came to Michigan, just when he walked into Michigan. Now here, you remember the headlines in the Journal. Anthony abused boy 3 years old in 1996. Now anybody who abuses a child that age, by definition, is a pedophile. He's a sick guy. Here's a synopsis of this whole thing that we put together, and there's a little bit of repeating, but let's see what this looks like, and we'll have some comments about what his attorney says and what the next step is and where it goes from here. Can you play that, please?
Judge. Today was the deadline for Anthony to surrender himself to investigators after he failed to register as a sex offender while living in mid-Michigan. ABC 12's Matt Franklin is live at the Genesee County Courthouse now with more. Matt?
And Larry, Genesee County investigators say that Julius Anthony was arrested just after 8 o'clock this morning. The prosecutor said in court that Anthony tried slipping underneath the radar by turning himself in here at the courthouse instead of at the Genesee County Jail. But either way, Anthony's attorney says that his client was surrendering. Now, in the meantime, this morning was the first time we have seen or heard from Julius Anthony since he resigned from the district in September. He was in court shackled and handcuffed with his brother in the room looking on. Anthony said very little and only responding to questions from the judge. Anthony is being charged for failing to register as a sex offender while living in mid-Michigan and for failing to notify authorities when he left to move to Georgia. Now, those are 4-year felonies. Also, there is a 1-year misdemeanor charge for violating the school safety zone because Anthony was working in the school district and was in school buildings. In 1996, Anthony was charged with molesting a 3-year-old boy in Fulton County, Georgia. 4 years later, he pleaded guilty to a lesser charge. Currently, his attorneys are trying to get that conviction removed from his record. In the meantime, his attorney says that there are a lot of beliefs, that there are a lot of underlying motives here in the Genesee County case.
Every day people come in voluntarily and turn themselves in. We don't have this mass media here for it, regardless of what the offense is. Well, you have offenses that they want to make a big deal out of, and this is one of them. He's caught up in a political fight here for some reason. That's my take on it. That's what we believe.
Now, Anthony is expected to be released on a $20,000 personal bond. As a condition, he is not to be alone with minors unless an adult is present. He does have a court date in Atlanta, and he will also...
And Georgia never informed him that he had to register.
Harrell Millhouse says Anthony is currently working to overturn the Georgia conviction. If that happens, he says he is sure that Anthony will prevail in the Genesee County charges.
But once that is cleared up, we are extremely confident that that will then take care of this matter.
We do understand Mr. Anthony is headed back to Georgia. He was...
Longtime friend and business partner of Superintendent Walter Milton. He first came to the district as a consultant in December 2005. In July 2006, he was hired on as the Director of Curriculum and Instructional Services, pending a criminal background check. But he resigned in late September after an ABC 12 investigation revealed he had previously been charged with child molestation in Georgia. The superintendent has maintained he knew nothing of Anthony's criminal background. Calls made by ABC 12 to Walter Milton about today's developments were not returned.
It's a school on edge tonight. A bad car crash today.
Assaulting a 3-year-old in Georgia several years ago, but he failed to mention that when he applied for work at the Flint School District. Anthony resigned after investigations showed the criminal record, and tonight he's back in mid-Michigan. TV5's David Custer has that.
Here it is. This is Julius Anthony's mugshot. He was arrested this morning, and he was in court here in Genesee County facing 3 felony charges.
Yes.
It's the first time Julius Anthony has surfaced in Genesee County since resigning from the Flint School District in September.
Mr. Anthony has traveled here from Georgia.
This time in shackles in Judge McCara's courtroom. Anthony was formally charged on 3 felony counts for failing to register as a sex offender while in Genesee County. This after a background check by the school district revealed a sexual battery conviction in 2000 stemming from a child molestation charge. The prosecutor and sheriff issued warrants for his arrest more than 2 weeks ago, setting today as the deadline to turn himself in. Currently living in Georgia, he arrived in district court around 8 this morning, and that's when he was arrested.
Mr. Anthony showed up here in the court despite the agreements that he made with the sheriff and with an assistant prosecutor in my office, and tried to get arraigned and slip back out of town so you wouldn't see him, so he wouldn't get fingerprinted, so he wouldn't get photographed.
And there was no going under the radar, not trying to be slick, because once you show up at court, you're going to go through booking, you're going to go through the process.
The prosecutor stood up stating Anthony was a flight risk after breaching an agreement to turn himself in to the sheriff.
And to believe that for the protection of the public, we have to make sure that people are booked properly, are photographed and fingerprinted.
Meantime, Anthony was granted personal recognizance bond at $20,000 so he can appear in a Georgia courtroom as he attempts to get his sexual battery conviction overturned. Anthony will be back in the Genesee County courtroom next Friday, and there's more to this story. Here's a sneak peek of what's coming up at 6.
Yeah, y'all can get out my face. That's my reaction.
Reaction from today's story that you don't want to miss.
Anthony's attorney brought his client in to turn himself in. According to the Genesee County investigators, that was not part of the deal, which is why he was arrested. Only ABC 12 was there as Julius Anthony left the Genesee County Jail this afternoon and hopped into the back seat of an awaiting vehicle following his court hearing. Anthony left the talking up to his attorney.
We're just not happy with the way things, the way the process was handled.
Harold Millhouse says Anthony had the option to either turn himself in at either the courthouse or at the jail. However, he believes Genesee County investigators have other reasons for wanting him to surrender at the jail.
The purpose is so that they could humiliate him, to embarrass him, to handcuff him and shackle him. Why should
There was a warrant. He was supposed to come to the sheriff's department. He didn't. He was arrested here at the courthouse.
The former Flint school administrator answered felony charges this morning for failing to register as a sex offender while living in mid-Michigan. An ABC 12 investigation found in 1996
a botched matter in Georgia where this all resonated from.
Our calls to Superintendent Milton were not returned.
Because once you show up at court, you're going to go through booking, you're going to go through the process. But if you turn yourself in over at the jail, you got to get handcuffed, you got to get shackled, you got to ride in the police car. Would you want to do that?
A judge set a no-cash personal bond of $20,000.
Pretty much what we wanted. We got the waiver of extradition was helpful. We have no contact with children, which is most important because that protects the public.
Anthony resigned from Flint schools after a background.
Well, let's face it here. In my opinion, Millhouse is clearly wrong. What he was trying to do was to bring Anthony into the court and have him arraigned by the court calling and getting the warrant that charges him violation of the state law for not registering as a sex offender. He'd get the warrant. He'd go into court. Judge would say, how do you plead? Or I demand a preliminary examination. All right, it's a personal bond. And out the door he walks. The judge is not responsible to fingerprint him and to get a mug shot. That's the sheriff's responsibility. And they made a deal with Millhouse and Anthony that he would show up there, or at least Millhouse counsel, whether it was the one in Atlanta or whatever, would show up there in the sheriff's department for the purpose of giving him or taking his mugshot and getting his fingerprints. They gave him consideration that Millhouse obviously didn't give them. He didn't show up there. He tried to beat the system of not getting printed or mugshot. Now, invariably, what happens is if you've got an arrangement with an attorney, he will keep it. Now, Millhouse, obviously, the sheriff and the prosecutor are not going to rely on his promises in the future. Once is enough. But once you have made the arrangement with the sheriff, you go to the sheriff's office, you get mugshot, you get your prints taken, and then there's arraignment in district court and your attorney's there. They're not going to handcuff you. They're not going to do that. They're not going to put in your car. They'll say to the attorney, the arraignment's 10 o'clock, have your man there. That's invariably what they do. So Milhouse is trying to make something out of nothing here. The fact of the matter is, this guy was convicted in 2000 for sexually assaulting a 3-year-old child. No matter what Milhouse says about who's playing the whom here and who's trying to get publicity, that's ridiculous. This is, the Flint Journal mentioned the top 10 cases, stories that came out in the Flint Journal this past year. And number 1 was this Anthony case. So the public they have a right to know what's going on here in their courts, and the public relies on the press to provide them that information. So to suggest those things, and you know, it's kind of ridiculous. He says Milhouse is not happy with the whole process. Well, he caused the problem by not doing what was promised to be done. Now he shows up at the court downtown, the sheriff is waiting for him to appear at the sheriff's department. Walks into the court, wants to go get arraigned on the warrant that's in the court, and somebody sees him there from the sheriff's department and calls up the sheriff and says, hey, this guy's here. Now they know he's not keeping his promise, so they go down and arrest him. Because now they know he's not coming in voluntarily. They got to arrest him. And that's why they arrest. They put him in shackles. He wouldn't have suffered that humiliation if he had done what he had promised to do. So, you know, and now this idea of you know, it's going to Georgia and getting the case dismissed. You know, it's hard for me to believe that the Georgia authorities would let this guy withdraw his plea after 7 years, you know, on a 7-year-old case, in which he pleaded guilty of assaulting a 3-year-old child. You know, granted, I don't know the political opportunities that people like Anthony might have in Atlanta. Let's hope they do the right thing. But it wouldn't make any difference, even if they dismissed it. You know, even if they dismissed the charge against him. The case here revolves around him coming to Michigan with that criminal charge on his record that he pleaded guilty to, and he failed to register. He failed to register. That's the crime at the time he came to Michigan. Claims he didn't know he had to register. Did he not know he couldn't lie on his application? Because when asked that question on his application, he said he had no criminal convictions, which was a lie. So we're going to be interested to see what they do in Georgia. You know, in my opinion, his friend Milton knew of his conviction. And there was something he said here about 3 or 4 weeks ago, Walter Milton, the superintendent of schools, that was a criteria he tried to throw out there of why he didn't know. He claims that when Milton came to the Flint area, he stayed with him in an extra room he had for 2 weeks. And as a result, he was suggesting that in 2 weeks, he couldn't have found out about all this personal information about his criminal record. Well, but what he forgot to mention when he was making that statement is that and using the same criteria he wants to use to show he didn't get the information, he didn't tell you that he'd been living with this guy off and on for 7 years. Actually, about 6.5 years while in Missouri, while in New York. They worked together, and he was his partner. He was his closest friend. Now, if the same criteria would hold that he didn't know and he couldn't find out in 2 weeks, then the criteria when applied to 7 years would indicate he did not find out. He had plenty of time to find out. You know, Milton was reminded for numerous months by school board personnel to get his fingerprints in so he could be checked. He and Anthony were the only two that didn't have it in. He knew if he was printed, Anthony would have to be printed too because he'd be the only one left. And the cat would be out of the bag. You know, what other reason would Milton have to openly disregard the constant administration notification to get his prints in? He didn't have any record according to the records. And he probably would never have done it if it wasn't for the Flint Teachers Union, who filed a Freedom of Information and said, I want to see the records. I want to see what the fingerprints showed for Milton and Anthony. Well, there was no fingerprints. He hadn't taken it yet. So if they didn't get it, if the Flint board didn't, or the Teachers Union didn't get it, they would have filed a lawsuit and won the lawsuit. They would have been ordered to give the fingerprints. So Milton said, hey, you got to walk the plank, apparently. So he went and got his fingerprints. And Anthony went and got his, and bang, up comes the record. And then he resigns. And Milton says, I don't know anything about it. I think he did. And I frankly think he should go just like Anthony should go. Now let's go to the next subject I want to mention here. And I want to update you on the Argentine cop that, in effect, did not arrest a woman and her cousin he had pulled over for a traffic offense, allegedly if she would show him her breasts. Now, Genesee County Prosecutor Layton said, even if true, there was no crime committed. When we reported this event, we told you, based on the general definition of extortion, we said the facts fit the definition. Layton said no. You know, here's an Argentine police chief. He refuses to put the cop back on the road because he believes when a cop is asked about it and he takes the Fifth Amendment and refuses to admit or deny it, he shouldn't be on the road until he finishes the investigation. The politicians up there have threatened him, told him put him back on the road or you'll be disciplined. I think he's on his way of getting fired, but you got to give him credit for his integrity. You know, he's just not going to close his eyes to what he considers clear wrongdoing. Now here's television's report on this. Can you play that, please?
That has left one officer suspended and a small town questioning whether a crime was committed. TV5's Lori Jane Gliha live in our newsroom with more. Lori Jane.
Katie, this all comes down to whether a police officer actually did something wrong and how the township board and how the police chief are investigating it.
A traffic stop several months ago in Argentine Township seems to have sparked a bit of friction between the police chief and the township board.
I wish that they could pull together to accomplish more.
The ongoing feud is nothing new, says Holly Gall. She's lived in the township for 20 years, and this time the friction started when a woman accused an officer of allowing her to show her breasts to him. In exchange, he'd let her friend, facing a misdemeanor warrant, get off the hook. The alleged incident led the chief to investigate the officer, and when the officer tried to resign, the township board refused to accept it. Instead, they voted to put him on administrative leave. TV5 could not reach the chief tonight, but his attorney tells us the chief wanted to pursue the investigation a little bit further. As a result, he felt the board targeted him and started harassing him by, quote, micromanaging everything he did. That's when the chief filed a lawsuit against the board.
I wish that everything could work cohesively.
A few township residents say they've been in the dark about all the intricacies of the turmoil, but watching the government at odds is frustrating. Some wonder whether it will ever go away.
Personal agendas should always be put aside for the good of the community.
And tonight I left several messages for the township supervisor, but I have not heard back from him yet. I also was not able to get a hold of any of the other township board members or the trustees. Live in the Genesee County newsroom, Lori Jankley-Hott, WNEM TV5 News on Fox 66.
All right, Lori Jane, thank you.
Now what's important here is this was not just a traffic stop. And this becomes important when I move on here. This was for he waived arresting him on an existing warrant out of Shiawassee County. So here we have a traffic stop for what he apparently, the cop said was a violation of the traffic laws, and when he checks the guy out, he finds out there's an existing warrant. And I'll tell you, as I mentioned to you at the beginning here, I have some information I want to share with you, and I got this information because I wasn't really satisfied with Layton's conclusion, of no crime committed. So I decided to do my own research, and what I've found will have to conclude that the people in Layton's office, who I'm sure advised him and did the research, that there was no crime, apparently didn't really do the research and made a decision from the seat of their pants. Here's what I found that they apparently missed. This is a case out of Detroit. It says defendant city, there was a criminal case and a civil case. This is the civil case, but it talks about the criminal case. Defendant city of Detroit appeals on the right from a judgment of $2,625,000 entered on a jury verdict allocating 35% against the defendant and awarding $7.5 million as a result of violation of the Elliott Larson Civil Rights Act. And it goes on to say, here's what the action was. They got all this money, but besides that, listen to what happened here. This case arises out of conduct committed by a Flint police sergeant, David Witherspoon. Witherspoon admitting to pulling over 3 plaintiffs on separate occasions for traffic stops in 1999 and 2000. Instead of issuing tickets to the plaintiffs for alleged traffic violations, Witherspoon initiated sexual contact and photographed plaintiff Moody and Diamond with their breasts bared. He wasn't going to give them a ticket if they bared their breasts, and they did. They got $7.5 million. But more importantly, regarding plaintiff Bennett, the third woman, Witherspoon photographed her while clothed, pulled at her dress, and attempted to touch her. It is undisputed that Witherspoon pled guilty to 3 counts of extortion and 3 counts of criminal sexual conduct. In connection with the plaintiff's assaults, Witherspoon is currently serving concurrent sentences of 3 to 15. Those were for the 2 that he never touched them but just had them bare their breasts. Like this case, he's serving 3 to 15, and on the one he did touch, that count he's serving 3 to 20. And this case, wasn't hidden. This case is out of the Court of Appeals, and it's pretty clear that it happened. This case was published on April 12, 2005, a year and a half ago. Didn't they see that? How could they just ignore that? And keep in mind, this for just traffic offenses that he was stopped and he made them bare their breasts. In this case, he not only didn't issue a traffic offense, but he didn't arrest the man on a warrant because she bared her breast for him. This guy, clearly, it's extortion. That's what the court said. This guy went to jail for 15 years. There it is. Same case. It's what you call on all fours. The facts are the same. Even worse in the Argentine case, in my mind, because you had the traffic offense and the warrant that he waived on. The issues are the same. The results are the same. And all the conclusions are the same. How could the prosecutor tell me that there's no crime here? How could he tell the public there's no crime here? You know, it's a tragedy. I would hope that Leighton would have the courage now, in light of the case that we've presented to you here, to look at this case again. Or if they knew about this and didn't say anything, I think that would be deceitful. And I don't think Leighton is deceitful. I just don't think his people did the research and came up with the case. Because if it was brought to Leighton's attention, he wouldn't come out so, clearly saying that there was no crime. Because this shows there is a crime, in my opinion. You know, why do the women in Wayne County, according to this case, get greater protection from their authorities, from sexual deviates, than we do in Genesee County? Like I said, you women driving through Argentine better go around if you can, because no telling what's going to happen out there to you. And these politicians out there that are trying to protect this guy, who have a responsibility to the community to get rid of him, never denied this until the township board got involved. Didn't deny it to the cop when he was the chief when he was originally charged. He even took the Fifth Amendment when he said these allegations have been made against you. I'm not talking Fifth Amendment. Well, anyway, let's go to the next matter here. There's a kind of an audacity of the majority of the Burton City Council to appoint Ralph LeDuc, a Smiley apologist, to the vacancy on the council that resulted from Councilman Jamie Curtis being elected to the County Board of Commissioners. You know, in 2005 election for the City Council, there was a clear mandate, in my opinion, by the voters of the city of Burton to put the brakes on Mayor Smiley, who is subject to a corruption investigation right now by the federal government. Then to put the guy in the council who owes his very political existence to Smiley and who is directly involved in the Pebble Creek subdivision investigation, that is the primary area of investigation by the federal government into their corruption investigation, is a slap in the face of the citizens of the city of Burton. You know, what really is something here is, it's almost laughable, is LeDuc's comments after he was chosen last week. He says, look, I am looking to bring harmony to this group. I have no hidden agenda, no allegation or allegiances to anyone, LeDuc said. But he did say that he felt that Charles Smiley has done a good job and continues to do a good job. He says, overall, Smiley has done an excellent, not a good job, an excellent job. Now, he says he has no allegiances and no hidden agenda. Well, let me tell you, here's some things you should know. One son is now working for the public, working for the city for Smiley. He was hired by Smiley's people. Another son is working for, and one of the top people that he got hired at Young's Environmental, a major contributor to the Smiley campaign, and the main recipient to Smiley's non-bid contracts. And he's also has some kind of a contract, a weeding cutting contract with the city of Burton. I mean, it's $25,000, $30,000, $40,000 a year. And this is a real one. Recipient. This guy is a recipient of Smiley's generosity of granting an extra $10,000 to his salary on his last week of work before his retirement that increased his pension by $400 a month. And the people of Burton pay for this. There's no contribution by the employee, these Smiley appointee employees. Now, the rank and file people, the little guy, he contributes to his pension, but not these big guys. So he gives him an extra 10 grand that's computed into his pension. He gave him totally $20,000 extra that year. $10,000 in February, and then the last week in December, $10,000 more. Boosted that pension way up. He's also the main player in the Pebble Creek subdivision, city bonds budding scandal that the feds are looking at. This was a no-bid contract for streets and infrastructure given the young environmental. The sky's the limit with a no-bid contract. And he got there. And incidentally, there's an interesting sidelight to this, that LeDuc may not have been appointed legally in the first place to the city council. This was a special meeting, and under 4.7L in the Burton City Charter, at a special meeting, in this case to appoint, fill the vacancy left by Curtis's election of the county board, you have to have 4 votes. 4 votes. You can't do it by just a majority. You have to have 4 votes. He was elected by 3-2. So there's some serious question there whether he even should be. You know, it's going to open up Pandora's box when he starts voting on contracts or not voting on contracts. Business people who have been screwed by Smiley and will continue to be screwed will be suing, saying, well, the Duke shouldn't even been voting on that. And now we have, you know, this thing with the city council where the Attorney General sued them for taking retroactive pay, which was illegal under the Constitution. And this happened about a year and a half ago. And right now, the Attorney General has sent letters to Carolyn Sims, who is presently on the board, and 3 people who are no longer on the board, Ed Taylor, Mark Horrigan, and Johnny Coleman. Here's the letter they sent to Carolyn Sims. First, can you play that video for me, please?
Several current and previous city council members. Good evening. Thanks for joining us. I'm Joel Fike.
And I'm Angie Hendershot. Nearly 2 years after an Ingham County judge ordered members of council to repay money they awarded themselves, tonight the city of Flint says at least 5 city council members have not paid up. ABC 12's Matt Franklin live tonight at City Hall with more. Matt?
Angie, late this afternoon, the mayor's office released 5 letters from the Michigan's Attorney General's office that were sent to those council members telling them that they have until Wednesday to pay back the money. Now, according to the letters, current councilman Scott Kincaid owes more than $17,800. Current councilperson Carolyn Sims owes just over $16,800. Former councilman Johnny Coleman owes over $17,500. Former councilman Ed Taylor owes nearly $18,000. And former councilman Mark Horrigan owes just over $16,600. Now, the mayor's office says that it will go after the money if it is not paid by the Wednesday deadline. This all stems from a resolution passed by the council in 2004 to reinstate more than $250,000 in back pay just one day after the state takeover and the city ended. Now, council salaries have been cut by former emergency financial manager Ed Kurtz. The council claimed Kurtz had no authority to do it, but after several court hearings, the judge judge ruled the money had to be paid back. Now the city says it is going to uphold the current and former council members to the ruling.
So at this point, the judgment against them is final. The Attorney General has sent out communication to all those owing, and it at this point totals approximately $86,938. So the city will be seeking diligently to recoup these funds.
Now, I spoke to all 5 of those current and past council members by phone this afternoon. Johnny Coleman says that he has not received a letter from the Attorney General's office. Carolyn Sims and Mark Horgan declined to comment. Ed Taylor told me that he knows nothing about the judgment. And Scott Kincaid says that he did receive a letter and plans on sending in a check for the full amount by Wednesday. For Live at Flint City Hall, Matt Franklin, ABC 12 News.
Carolyn Sims, who is now on the board, or on the council, when asked why she hasn't paid this back in a year and a half, the letter here says that she owes $16,858.35. She has no comment? How about a comment like, I'll pay it? This case was decided by the Ingham County Circuit Judge who said you owe the money. Went to the Court of Appeals. The Court of Appeals affirmed the Ingham County's decision and said they have to pay the money back. The Supreme Court said it's so clear, they're not even going to look at it. So all the courts have considered it. You owe the money, pay it back. It's taxpayers' money. You had no right to it in the first place. But anyway, let me quickly just talk about, I have a few minutes here, about this Maples. And incidentally, the mayor has said that he was going to enforce this thing right away. And nothing's happened. I don't know what, you know, he could start a lawsuit for garnishment, attachment, and get the money back. And he hasn't done that. But anyway, Sugar Maple Farm development. Can you play that for me? Do we have time for that?
Let's grow to make sure all these things got finished and to make sure that City of Flint got paid back their money.
Despite that, Riley says the mayor told him he now owed more than $250,000 plus 10% interest. People who moved into the development before all this went down say that doesn't make sense.
You can't make somebody pay somebody else's bill. That's stupid.
Glenn Kelly says his home there was vandalized. He says someone covered the walls with human feces and tried to burn it to the ground. He's had to put in extra money just to make it livable again. Freeman Greer is the other owner. He just wants the mayor to listen to reason.
Please work with this developer and put this together so that we can move forward with the overall development of the subdivision.
And to make matters worse, Aaron, the developer says
Well, here's the problem. The problem is that the mayor takes a position, and he's probably correct, that the city has a mortgage on that for $200,000 and some thousand. And if he waives that, he could be charged with willful neglect of duty, because this belongs to the taxpayers. This money belongs to the taxpayer. He can't say, oh, you don't have to pay it. But at the same time, we have these people that are living out, or not living out there, trying to live out there, who have built homes, their life savings in many cases in this thing, and they're caught in the middle between the gladiators, you know, the mayor and this builder. So they ought to bring in a third party to mediate this dispute and move on, because these people are being injured.